judgment in the appeal, AMT Futures Limited and Marzillier.
Lord Hodge will give the judgment to the court.
This appeal raises a question of jurisdiction. It is concerned with the correct interpretation of Article 5.3 of Council Regulation No. 44/2001 of 22nd December 2000 on jurisdiction and the recognition and enforcement of judgments in civil and commercial matters. I will refer to it as the Judgments Regulation. The appellant, AMT Futures Limited, is a company incorporated in the United Kingdom and is based in London. I will refer to it as AMTF. AMTF provides services as a derivatives broker for clients who wish to trade in derivatives and who are referred to it by introducing brokers. Among its clients were people domiciled in Germany and other countries in the European mainland who were introduced to it by independent brokers based in Germany. AMTF paid commission to those introducing brokers. In its contracts with its clients, AMTF had an exclusive jurisdiction clause which provided that their contractual relationship was governed by English law and that the English courts would have exclusive jurisdiction in proceedings relating to the contract. Some of AMTF's clients were dissatisfied with the financial results of their transactions. They commenced legal proceedings in Germany against both the introducing brokers and also AMTF, seeking damages under the German law of delict. They claimed that the introducing brokers had given bad investment advice or had failed to warn them of investment risks, and that AMTF had encouraged the brokers to behave as they did by paying them commission. AMTF challenged the jurisdiction of the German court and estimates that it spent over £2 million dealing with the German court actions. It raised actions in England against its former clients who had commenced proceedings in Germany. It sues them for breach of contract, founding on the exclusive jurisdiction provision in their contracts. AMTF has also sued the German lawyers, MMGR, in the High Court in London, on the ground that MMGR committed the English law tort of inducing breach of contract by having persuaded the former clients to issue proceedings against it in Germany. AMTF argues that the English courts have jurisdiction under Article 5.3 of the Judgments Convention, which provides that jurisdiction will be established, and I quote, in matters relating to tort, delict, or quasi-delict, in the courts for the place where the harmful event occurred or may occur. AMTF argues that the harm which it has suffered is the deprivation of the contractual benefit of dispute resolution in England under English law, and therefore that the harmful event occurred in England. AMTF succeeded in this argument at first instance, but the Court of Appeal held that the English courts did not have jurisdiction, as the relevant harm had occurred in Germany. AMTF now appeals to this court. In a unanimous judgment, this court dismisses the appeal, essentially for 4 reasons. First, the court holds that the aim of the Judgments Regulation is to prevent parallel proceedings between courts of different member states. Derogations from the general rule, which confers jurisdiction on courts of the defendant's domicile, must be restrictively interpreted in order to achieve this aim. Article 5.3 is such a derogation. Secondly, Article 5.3 requires the court to identify where the relevant harm occurred. It looks to the place where the event causing the harm occurred and also to where the direct harm occurred. In this case, the raising of the proceedings in Germany was the event giving rise to the damage for the purposes of Article 5.3, and the direct harm was the expenditure occasioned by the German proceedings. Thirdly, it would be contrary to the jurisprudence of the Court of Justice of the European Union for the court to craft a special rule for the tort of inducing breach of contract, where the contractual clause which has been breached is an exclusive jurisdiction clause. It is the occurrence of direct and immediate harm which gives rise to jurisdiction under Article 5.3, and there's no need to develop special rules for this case, as the Luxembourg Court has done in cases involving transactions via the internet. Fourthly, the inconvenience of separating the resolution of the contractual claims against the former clients from the pursuit of claims against MMGR is the price to be paid for achieving the legal certainty and foreseeability which are among the principal aims of the judgment's regulation. Finally, the Court, having reviewed the recent case law of the Luxembourg Court, is satisfied that that court has not moved away from its established principles and approach to the interpretation of the judgment's regulation. The matter is acte claire, and no reference to the Court of Justice is mandated.